Okay, welcome back. We concluded our executive session on time. It did take us a few minutes to get everything switched around, so we ended at 12:02. I think we did extend for 2 minutes. It's now 12:06. Like I said, took us a few minutes to get everything back together. We are now joined by our Superior Court, and we will continue our budget presentations. So thank you, Judge McKay and Ashley Callan. I think I said Cameron the other day, so I got it right today.
It happens a lot.
It always does, mixing the two of you up. So thank you very much.
Thank you.
Yeah, I'm not quite sure. I was sitting in this seat about this time last year. I'm not sure that the budget has changed much since then, other than we now have the 13th position, which once that position is filled would need a JA as well as a court reporter, and then obviously we've had conversations about space. But other than that, the budget remains pretty much the same. I know that Ms. Callan had put together the PowerPoint. It is a PowerPoint, but it has been provided to you for review. It does show a 6-year graph so that you can see what the expenses are broken down between what are discretionary and what are non-discretionary, and then some explanations for what has impacted Superior Court, which impacts, I think, probably the non-discretionary portion of the budget and the caseloads. And they are itemized here. I know that you have just all gotten this information, so to ask you to ask questions of that might be a little bit premature, but it is there for you to all take a look at and ask questions of the court, since I don't know that too much has changed since the last presentation. And I do know that you have the budget that gets submitted with all of the actual specific numbers. And I know Ashley has those in case you have questions with regards to specific numbers. I would turn those questions over to Ashley since she has the graph. So other than that.
So in your 2024 budget request, I'm just going to confirm, so we've got the additional half the salary for the 13th judge, and then for you guys, it's the judicial assistant and the court reporter.
Correct.
And then,
That is correct. That is
that's already
in the budget already.
Okay. So just see. So what are the recent legislative impacts? Do you want to talk about those?
We sure can. I think that this has been something that we have presented on all along. What happens in courts has continued to become more and more complicated. And I'm not quite sure how to quantify that or to assist, give that information. So a little bit of what it is that we have is outlined here with regards to legislative impacts. One of those I think that Director Sparber can probably answer to, because he has taken on the piece of trying to find attorneys to step in and take over some of the minor guardianship cases where the legislation has said you will appoint attorneys for these individuals. You will have court representatives for these individuals in the minor guardianship or the guardianship type cases. And Director Sparber's office has been tasked with finding those, because GR 31, 49, 40,
42?
42. I don't have my numbers memorized.
It's one of those numbers.
One of them. A general rule basically says the court's got to be out of the business of determining who's that attorney appointed at public expense. So we don't have a choice. Those are what's there. But the law changed and it requires the courts to do things differently. So some of that information is provided here as well in the first slide, the Uniform Guardianship Act. Unlawful detainers, I think you are all kind of familiar with the changes that occurred once COVID hit. It has put us in a position of dealing with the backlogged cases because we couldn't do anything for so long. And then as funding was coming through kind of in I wouldn't call it fits and spurts, but the funding was coming through to address some of those housing issues for tenants. What is now left is the backlog of cases that we still have to address, as well as then the right to counsel. That did not change when the moratorium was lifted and some of the emergency provisions were put in place. From there, turning to our civil protection orders, I know that I have always used that kind of as an example of complications. We've always had domestic violence protection orders. It is now titled civil protection orders, and it encompasses a really broad overview of the types of orders. The legislation kind of put them all under one title. The changes there, what's not included in what I've kind of bulleted here, or what Ms. Callan bulleted for me, is that the definition of what is prohibited conduct, or what somebody could come petition for a civil protection order, has broadened. So what we would normally look at and say, that doesn't fit the statutory definition. It's much, much broader, so yes, it can. Those hearings are required to be on the record. The court's required to make findings. We are required to tell people you have the right to fix this. So if we deny initially a petition, they have the right to come back within 14 days to fix it. Even after a hearing, they have the right to revise, appeal, reconsider. So the amount of work that we do with regards to those cases are huge. I had a conversation with our commissioners who handle those dockets. The other day, they had 63 domestic or civil protection order requests on a docket. It took the commissioner 2 hours to call roll. So to get through what was on the docket, to determine what was ready to go to hearing. Well, when it takes 2 hours to go through a docket call, that then takes the amount of time that you have to actually address the hearings down to about half a day. So from 63 to having a half a day to do it, it doesn't work. In addition to that, we are now no longer able to set rules with regards to what you can present to the court. So in other words, page limits, providing us bench copies, providing a thumb drive that needs to be reviewed before it can be provided to the court. We don't have that. The legislation has basically said you cannot do that. We cannot ask for bench copies. We cannot require them to do that. So they show up on the day of the hearing and they've got 100 pages of emails that we are required to look at. Guess what? We're required to look at it. We don't have the option of saying, no, we're rejecting after a certain page. Thumb drives then have to go through the IT protective scanning. People come to court all the time saying, hey, I've got video on my phone. Will you take the video on my phone? Well, most of the time my response to them is I would love to, but the problem is if I take the video on your phone, I'm now gonna have to take your phone as evidence and I get to keep it for 30 days. No, most people can't be without their phone for 30 days, nor do they want that. So it's just some of those practical things that, as of the change a year and a half ago, are huge. District court still continues. They could take a lot of these hearings. They still continue to pipe things into Superior Court. The speaking system, we're still working on it. In other words, how we communicate between what comes from there to come to here. That's still a work in progress because of the vast numbers. So that's a good example of how things have gotten complicated. In addition to that, most of these civil protection order cases are tied either to a dependency case or a family law case. And I can tell you that the people that are in front of the court, they don't tell you that. So then you are taking extra time to make sure there isn't a family law case that may have some orders that are contrary to what the person in front of you is asking you to do. So it just has slowed things down and increased the workload tremendously. It's kind of a good example. Dependency hearings, as of July of 23, the requirements at the state level have changed. And so all of what we think our efficiencies here in Spokane County have changed, and they require hearings that where before there might have been an order that could be presented to a commissioner or a judge to say, here's what we're looking at. It now has to be done on the record. So us finding a time to have that hearing and a place to have that hearing has become quite, it's a moving pieces around, I guess, on a regular basis. The compliance reviews that have been legislatively required, now DNA submissions, that was kind of part of the booking process, but we are required to have a DNA protocol in place and then have a docket to put those on when people don't come in, where before, as chief criminal, I was able to just sign warrants for somebody who didn't come give their DNA, and it was a kind of a hook, take DNA and release type situation. We have to have then a protocol based upon the new changes. Very similar to firearm surrenders. There is a protocol and a compliance docket that we have. those, well, it expanded from 1 day a week. We are now at 2 days a week. And I did not check to see whether 2 days a week was meeting the caseloads or not, but there are those things. And then resentencings, I think the ones that you're most familiar with are the Blake resentencings. But there are other cases, the youthful mitigation resentencings, the Rob 2s. I think we're through the Rob 2s at this point in time. So that shouldn't be an issue. But every time legislation changes, it changes what we do. So overview, I don't mean to overwhelm, but things are just more complicated and complex than they used to be. Even probably 5 years ago, 6 years ago. There is, as part of our supplemental requests, the request for IT to address Superior Court. One of the things that I have recently found out, I guess I kind of knew it, you go about your business and you've got a computer in front of you that, as a judicial officer, I just kind of expect to work. I'll be honest with you, I have no idea how it works and how it gives me the information that I need. But in speaking with IT, there are about 7 programs, computer programs, that Superior Court alone uses to get all of its dockets doing what it should do. And I frankly do not know how they get each of these programs to talk to each other. And that's part of the concern. We are upgrading our courtrooms to add the technology to be more efficient and to provide more access to the public. But every time we do that, that technology doesn't talk to all of the rest of the stuff that we have going. And we've got someone from IT in our offices almost every morning. It seems like in one courtroom or another. So that is kind of the practical request for IT. And we did request that last year as well, so
that's having.
nothing new.
So that's asking for a dedicated person.
Correct. So with that, I don't know if anybody has questions about anything that's in this that you have the option to do. Or opportunity, probably is the word that I'm looking for, opportunity to ask questions.
I have a quick question.
Yes, Commissioner Jordan.
Thank you. The no page limit rule, is that, oh boy, that sounds like a lot of fun. Is that related to protection orders only, just those type of cases?
Correct. Superior Court does have page limits for the other hearings that we have for family law matters as well as the civil motions. Criminal motions never seem to have been an issue with regards to page limits because they don't usually have a lot of things to attach to a motion or argue, but it is the family law and civil where there are page limits, which then helps with the amount of reading that you have to do.
Commissioner French.
Yes, thank you, Madam Chair. About, I think it was about 4 years ago, the board with the court authorized an outside national agency to come in and look at the processes that the Superior Court engaged in and made a series of recommendations. Unfortunately, I don't have that in front of me. I've read the report, it's on my desk. But have those recommendations be implemented, and what was the outcome of that implementation? I know that the national group had pointed out a number of things where the court had allowed for too many delays, too many continuances, and that the average time for prosecuting was longer in Spokane County than other courts and stuff. So I was wondering, were you able to implement any of those, and what kind of successes have you achieved?
Well, we were, to my recollection, we were able to implement those. They were being implemented through our chief criminal department, and Judge Cooney was having great success in 2020, and then COVID hit. And I'll be honest, since COVID hit, we have not been able to get back to it. And it's pretty much as simple as that.
And is that part of what your new study is kind of is it the same type of study, I guess, that's the question.
Yes, but it would encompass everything that we do, which obviously criminal is just a fraction of the dockets that we handle.
And I know Judge Fennessy, who's our current chief criminal judge, he has been trying to get back to that more court control over the amount of hearings. And I'm sure that you've heard or soon will hear, you know, the fact that the PDs and prosecutors continue to lose lawyers either to retirement or going to the AGs, you lose that experience. And so even the most well-intentioned judge saying, well, no, I'm going to hold this case, the feet to the fire, and we're going to go to trial. If they get a brand new defense attorney a week before that trial date, if we force the case to go, then we run the risk of it coming back from appeal. So that's where we all work together. I mean, when the defense offices lose very experienced lawyers, it does affect the courts. And the same is true, although not quite as much with the prosecutors, because it's that relationship with the client. So it has, I know that we have been trying to get back to being more controlled on that case processing, but there's things that are outside of our control that make it a challenge.
Well, I had a question, Scott, for you about the first appearance. Well, the small courtroom that I think the idea is for the court commissioners to have first appearances. What's the status on the construction of that?
Targeting to be completed by end of the year, right? Mm-hmm. So Gil's been in active communication with Ashley, and I don't know if they've done the demo yet, but we have, that's what they're targeting.
I thought that I was told in a conversation as I was heading from my office over to juvenile to do the other half of what I'm doing, well, the 3/4 of what I'm doing. I ran into Gil, and he did say he thought demolition was starting, which to me would mean it should have started by now, but I haven't poked my head in to see if there.
I just hadn't seen much, so I didn't know what was, I didn't see a lot of activity over there, so good. I know that will help.
Targeting end of the year.
Dealing with the asbestos.
I'm sure.
Yes, that. Asbestos.
And
Historic buildings.
Yeah, well, that's,
somebody said that.
it doesn't come without its perks.
Another question, and I have to look at the IT department's budget, but is the IT department requesting any additional staff, just to their concern around just having, IT issues being addressed in a timely manner? Do you remember?
I don't
Randy's probably over
think so.
there,
I know Kevin's team has been actively working to be more visible. We don't really want to go out and put these other IT staff out in departments because we have an IT department. So we're really trying to hold that model. And if it's a service level that's not being met, that's something that Kevin needs to hear about. So he's providing the level of service that we're looking to provide. So that's what I understood, that he was purposely making sure his team was readily available because of the technology you guys use on a regular basis.
I think one of the, and again, I agree with you, I think IT, they do a great job. But for instance, Doug Russell, who does all of the AV for county as a whole, just last week, we had a court that was delayed, couldn't start because the AV equipment wasn't working correctly, and only Doug knows how to fix that. And Doug, I think, was out at the fairgrounds or something. I mean, so he is just one person that can do all of that work. And I'm not saying that if Superior Court had our own IT person that they could fix it without Doug. I mean, perhaps it truly is it's all in Doug's brain. But it is a challenge. I mean, when we're asked to run reports, data, all of those things, I mean, I can certainly do that rudimentary wise, but man, the departments that have an actual IT type position, I think can produce better results because I don't have a background in IT. I can click a report, but if you need me to like fine tune it and drill down, you've now gotten past my experience.
It sounds like what you're highlighting more is a business analyst that's diving into your data and whatnot, not supporting what I would call IT help desk sort of stuff, software, hardware, that sort of thing. If our issue on single individual with knowledge exists, then I think my challenge back to the team would be you need to cross-pollinate that so we have multiple people with expertise. So I don't know personally if Doug is the only one. I know he actively works with the other AV around here, but I think that's something that we want to make sure there's good, because Doug's not here every day of the week. He's going to take some vacation. So what's our backup plan?
Just a second, I'm gonna ask a question first. So like on the data though, shouldn't, Mike, you've got someone who does data, that if there's reports and stuff that you want, I mean, we need to be using the resources we already have.
And Aaron Lynn is a big help on that part of it because he's got all the detention services data. And then we have Diane as well that can do that part of stuff. We just, we just need to know how we can help you and we'll help you with that part of it, so.
Yeah, because I know data's analysis and diving into that's a unique skill set.
Right.
Again, so I mean, so we have people that can help with that.
That'd be great.
So yeah, so Ashley.
And what I was gonna speak to that is, so IT has recently hired 2 more people, so they're working on cross-training right now for that position, but also they are different positions. So if you're looking at a report runner, a data analysis, to Scott's point, that's more of a business analyst rather than an IT person. So we're happy to help kind of figure out where can we look at that as well. But just from an AV perspective, they have recently brought on 2 more people that are fresh and wonderful and amazing, but they're just starting to get their feet under them for cross-training.
And I would say from at least my perspective, I don't think that the IT individual we're asking for is just data related. Because being able to convey what the court does to IT so that they speak the same language to make this program work the way that it's supposed to is what we're looking at. It's not just data.
Yeah.
Because understanding what we do, if the IT person trying to fix our program doesn't understand why and how we need it to work, it's not gonna work. So if you have somebody who understands how the court operations works, who can convey that, and they talk their language versus our language, is really what we're looking at, because that's the problem right now, is trying to have that communication and conversation with someone who doesn't do this on a regular basis, who serves countywide, and then we have this very specific problem with a program for us to do our job. That's the kind of IT person that we're looking for, that I believe district court has. So.
Commissioner Jordan.
Yeah, obviously we don't have IT here, but I'd be, maybe Scott or someone else could answer. I'm just kind of curious, looking at the PowerPoint, if it says, seems to indicate that a couple other departments have a kind of dedicated IT person, and maybe what the history is there and why certain departments do and certain don't. It's just a question I have that I don't know the answer.
Yeah, I'm kind of going off memory here, Commissioner. I think the prosecutor's office has a help desk type of a person, I think, which whenever the decision was made, it doesn't make sense to me if it's a high help desk person that really needs to be in IT. Detention services, likely, I know they have a business analyst, as you can imagine, with their the size of their budget and the number of people in the various departments or other jurisdictions they do business with. They have a lot of data needs, and this will actually be even bigger because there's probably 10 other departments that have those types of folks in there, and I'm sure sheriffs does as well. I don't know what district court and juvenile have. I've heard district court has an IT resource, but I don't know what they do.
They're primarily a business analyst. They don't have rights to go and do any of the IT stuff that Kevin's people do. They specifically don't have those rights to do that because we can't have them doing that stuff. Right. They're really a business analyst, which is in our environment The only reason they're needed is because we have all these homegrown systems that don't talk to each other. If we would get off these homegrown systems, we would not need those business analysts.
Traditionally, kind of the centralized versus decentralized, from what I've seen in the last 3 years, it's just been a change in model, right? We've really started looking at, instead of each department having one dedicated, how do we share and cross-train to this purpose, right? So you don't have one person. So as we've been looking at departments like IT, what we found is when we have it very desegregated, we've found a lot of people working on similar solutions that we already have, like one group standing up a training site when we already have a training site that we're paying for, right? And so we've kind of we've segregated it out so far that we've lost sight of that central office and what solutions do we have, speaking to Randy's point of kind of homegrown. So I think moving forward, the question for the organization is, yes, we need to ensure that groups like Superior Court have the support they need, but what is the position and then where does it most make sense to house them from a software, a needs, and a staffing perspective. So it's kind of been an interesting 3 years as we've been starting to work through some of that.
And the courts all have different systems. There's discus, SCOMA, I mean, so they're all,
Names are great.
yeah.
Superman, SuperCal, Davies.
Yeah.
Super now,
Yeah.
I mean, you start having one.
Although I will say, to the point of homegrown versus an off the shelf, the state software that the clerks rely on is an off the shelf. I can guarantee that we don't utilize that software to the best of its ability because we just don't know. And there's not enough time in the day to tell somebody on your staff, hey, I need you to just dive in deep to this software. Where again, somebody with an IT background, they would learn how to do all of the tricks and shortcuts and things like that. So even with an off-the-shelf product, you still need somebody to then, you onboard a new employee, somebody to sit down with them and say, okay, this is all that you do. We're just kind of at a crisis point. I feel like I say that each time that we're down here, where, we don't have the time to sit back and find all the shortcuts that we could. And I think that the departments that do have somebody with an IT background have the ability to do that because they know how to explore software and the rest of us don't.
So are the programs, Judge, you had mentioned there are 7 different programs that you guys utilize. Are those off the shelf or are those homegrown?
Those are homegrown.
Those are homegrown. Okay, so those are programs that you have to use to some extent throughout the day to.
My judicial assistant in creating the dockets for the dockets that I do has to work out of 3 separate computer programs.
Okay.
Pretty much every day, which is fine. She's got it down. But if one of them goes down, then part of my docket I don't see and she can't convey to everybody else that's in the system. The AG's office, the prosecutor's office, public defender's office, the clerk's office, probation, juvenile probation, detention, things like that. They don't see it. So detention, like adult detention.
And it's one of the items that was mentioned, the blueprint of reform, but it's a big lift. So, not saying it's not, it's a big lift, that's really it.
I just want to say, it seems, I totally get what Ashley Cameron is saying about the centralization versus having a dedicated staff person. And I don't know what the solution is, but it does seem like a pretty significant public impact when a court system is trying to have hearings and you've got a packed docket and you've got people all over the place and jurors and your computer goes down. Having that timely response and having the IT really able to be managed well seems like it's a pretty big deal for the public. So hopefully we can work that piece out regardless of what the solution is.
I mean, if it helps, I have 2, 3, 4 computers that I work off of. They all need to have all of those programs available to it. So far, I've got 3 that have been updated and I'm just kind of limping along with the 4th one because it's like ships in the night. I pass it at the speed of sound, but I've figured out how to get where I need to get to look at cases before I take the bench. But so it was quite interesting when I didn't have access to any one of my 4 computers. It was a bit of the sky is falling and, oh, holy crap, what do I do now? IT was very responsive in getting me up and rolling on my benches, but then got pulled away to the other judges who needed the very same fix, so that things internally weren't available for a while. So just another example.
But if a program is going down, is that campus-wide where all the judges, that program is not available? Or are you just talking about something specific to your computer, something
It's
went down?
across the boards, being
Okay.
able to look at, I think an upgrade went into place, but when the upgrades
Yeah.
go into place, it doesn't change how I get there, so it
Yeah.
all had to be upgraded both internally and what I would call from the operator side of things, and there were 20 of us that needed that. Well, I shouldn't say all of it, because I use EdgeViewer, Superman, SuperCal, but not everybody has to use that, so it wasn't all 20 people. Plus staff.
So the grant that we just approved last week to look at different improvements, will it be looking at the IT side of things, or do we pretty much know from the blueprint, like, what are the ultimate software kind of upgrades that we might want to do? Will this be related to that at all?
And I'm just gonna
No.
correct, that was a contract, not a grant.
Oh, contract.
That's right. No, I don't think they're going to necessarily look at our IT software. I agree it would be a really big lift, because since our software is homegrown, it communicates with the jail and the PDs and the prosecutors. And so it's not just a Superior Court utilizing this homegrown software, they're all integrated. And again, not critique of IT at all. I think Kevin and his team do a great job, but each time there's an upgrade, things kind of break a little bit, and they break a little bit more. And so we've kind of hodgepodged it all. So to replace the court software, to do it right, we would need to replace the criminal justice software, and it's and it's a big one. And I will say, like I said, the clerks use the software that's an off the shelf from Odyssey that the state provides. We're going through upgrades for that at least once a year, and it tweaks things, just like when you get a new Word. You log onto your computer and Word doesn't work the same way that it did when you left for work. And so it's just those little tweaks that are really, we find ourselves being really reactive to instead of proactive, and that's a frustrating way to work.
Thank you.
Any other questions? Obviously, what I would say, if anybody, after you look and kind of dig into just the brief overview, if you want more specifics, if you want more examples, if you want more details, I am absolutely happy to provide those with you, to you. I know that Ashley is available, just kind of to hit the high points with examples to provide, but there's more that we can show, demonstrate, provide, and go from there. So, thank you.
Thank you.
And I'll get back to you on hopefully what I find out Friday. Friday.
Then that's gonna take us into 2 more executive sessions.
Yes.
Not all 20 minutes.
We will do our best. So I have 2 executive sessions, both under RCW 4231-10-1I for pending potential litigation. The first will involve the board, Scott Simmons, myself, Josh Grote and Ashley Cameron from HR, and Tim Nault from my office as well. And then the second will be the board, myself, Scott Simmons, I think, and that'll be.
Oh, he's not gonna be here, never mind.
Yeah, and that will be it,
So that's just the board, Scott.
yes. And anticipate 20 minutes for each of those, no action on either.
So we're gonna go into executive session for the next 40 minutes for the 2 items just listed with the people that will be in attendance. It is 12:41, so we will be in until 12:21, or 1:21, sorry. 21. No action anticipated, so we will adjourn at that time and see everyone tomorrow.
Yeah.
Thank you.